me just handle it because we're live streaming now. Give me just a minute. I might actually give you a new date.
Live streaming on YouTube?
Yeah, we live stream the minor guardianship hearings.
Oh, okay. I didn't know that.
So when I was looking at this file, a couple questions came up for me. And again, thanks for sticking in with us while we get through this little hiccup. I'm not seeing service yet on either of the parents.
I don't know where the father is. He has never been in Xavier's life. We've had no contact with him. As far as Amanda, I do not know how to serve her. She is in Utah. She is living in her car. She's homeless and jobless. She calls me sporadically from a gas station phone. I don't know how to serve her. The only contact I have for her, because she doesn't even have a phone right now, I can email her if that's okay. I don't know what else. I've told her about the meeting. I don't see that she's here. I did
Yeah,
email
this is,
her.
well, I understand, but unfortunately what you have done is not enough for the court to deem it proper service. I also have questions about jurisdiction over the child. For the time being, I'm going to find that we have temporary emergency jurisdiction. I will find that the child was in this state prior to July and has been, at least at this point, the allegations are abandoned here and does need emergency protection in this state. However, we're going to set a new date and a couple things are going to have to happen. So the jurisdiction of this court could change because, as I understand it, the child was in Utah July through December. I understand right now the allegations warrant me finding temporary emergency jurisdiction because he is back in this. He's in Washington with you now.
Correct.
Based on her phone call to come pick him up.
Yes, he has been with me off and on for the last 8 years.
Okay. So I am right now just going to find that temporary emergency jurisdiction, but it is something that is going to need to be dealt with at a future date. You will have to make attempts at service on both parents. If father is on the birth certificate, you have to attempt to serve him. It's not enough to say, I don't know where he is.
I don't know if he's on the birth certificate, to be honest. I don't know.
Well, you'll need to find that out. The court can't do that for you. That's all stuff you've got to do.
Okay.
What I am going to do to help you, though, is appoint a court visitor. I don't know who that person will be yet, but the court will notify you. I will fill out the order appointing a court visitor today.
Okay.
That person can help you determine how to serve. And if the court visitor deems that you've made all reasonable efforts to contact and haven't been able to, the court visitor can then talk to the court about approving electronic service, service by mail, those sorts of things, or even publication if we know what city or county they're in.
I do. Amanda's in Payson, Utah.
So this is all information for the court, you and the court visitor to talk about. Okay. So I'm going to extend the ex parte order. I'm going to assign a court visitor. Because we were able to get logged on instead of Thursday, I'm going to set you out a little bit further to give time for the court visitor to meet with you.
Okay.
Let's look at January 16 at 10:30 a.m.
What day is that?
That is a Tuesday at 10:30 a.m.
January 16th.
Yes.
Okay.
And then the court visitor will have your contact information. Let me just make sure the information on your petition is all there. Okay. All right. We'll get that over to them and we'll see you back on January 16th.
Okay. Do I need to come down to the clerk's office to get the extended copy of the order?
Yeah, you probably will. They don't get emailed, the copies, right? Yeah, you'll need to come down and get a copy. You can do that later today, tomorrow.
Okay.
Thank you.
Okay. Thank you so much. I appreciate it.
Yep. Again, due to some technical difficulties, this session got started about half an hour late. I would just note when I reviewed it, it looked like a guardian ad litem was just appointed on 12/21. And at that hearing, the court indicated that they would be striking this week's hearing and instead renoting the matter for February 22nd, 2024 at 10:30 a.m. And it looks like that is the date on the immediate order. So I'm going to go ahead and just strike this matter. I will note when we were originally trying to log in, I did see the GAL Ms. Day logged in, so she was trying to be present for this. Anything else you need from me? Okay, we will go ahead and end docket. I'm going to go through just in order of the cases I have here. Several of these are review hearings, so I'll start with those. But let me just first ask, are there any parties that are going to be asking for additional time before proceeding today, or they're going to be asking to have a matter taken off of today's docket?
I am, Your Honor, Rebecca Mills.
Okay, let's go to your case, Ms. Mills. Do I have Samuel Mills present?
I am present.
Okay, and I think I saw Ms. Day already. Good morning, Ms. Day.
Yes, Your Honor, I'm here.
Quickly. Okay, just a minute. I originally had this on for presentation of temporary orders. So Ms. Mills, why don't you go first and let me know what you're requesting today?
I don't know exactly what day I was served, but I know I had less than 10 days to respond. And with the holiday made that kind of tricky. And I was also in the process of moving. So I was not able to submit my response until yesterday morning. So I'm not sure if you even have that, but I would just like my things reviewed before we make any decisions today.
Understood. So let me just get a little history here. It looks like back in July, there were temporary orders signed. And then what I have in front of me again are proposed temporary orders. So we can talk about that in a minute. But Mr. Mills, I'll turn to you here in a second. I am seeing the declaration affidavit for, oh no, that's for Ms. Mills, excuse me. Your note for motion docket for today didn't have any proof of service with it. And under our local rules, we do require that the other party be given at least 21 days before it would be noted for hearing. So it's not timely based on what I have in front of me. So Mr. Mills, are you objecting to continuing this matter?
No, she's had it and she's responded. I have a response and she's filed her response. I don't see why we can't just do it now. It's not going to change. She's not filing anything new.
Okay, well, I'm telling you, your note for motion docket was filed with us December 7th, and she is saying she wasn't served until just about 10 days ago. So I'm telling you that it's not timely under our local rules. If she wanted to proceed today, she can waive service, but she is telling me that she does want that additional time. Have you received her response?
Yes.
Okay. Ms. Day, any input on your end?
My only input, I'm not looking at when service was done, but I thought it was close to the date of filing, so the 8th or the 9th. So it might not be the full 20 days given the holiday. So I think that that's understandable. I would ask that it not be set out more than a week or anything additional to that, because the responses have been filed and the concerns in this matter should be reviewed by the court at the earliest possible date.
Okay. And is it true that we're doing another temporary order? Is that the request at this time?
Father is asking for a temporary order due to the concerns he had in mother's home with her new partner and change of residence and some other allegations that were made in that. So he was asking to have at least temporary custody of the children due to those concerns. Mother's response is her attempt to allay those concerns, which is why I thought it should be reviewed sooner rather than later.
Yeah. Okay, give me just a minute here.
And Your Honor, Ms. Lindy for the state on behalf of child support. I was just reviewing the docket and saw that there is a temporary child support order that should be before Your Honor. We were not served with a copy of that, so we would be requesting a copy of that before any decision was made about changing child support as well.
Okay. And it looks like there are two, Ms. Looney, just so I tell the parties the right thing, would you want each party's proposed new temporary order?
We have information from Mr. Mills that we received on the 22nd. If Ms. Mills has filed additional information, we would need that as well, Your Honor.
Okay. And I do believe we just got that. Actually,
in
Ms.
Mr.
Mills,
Mills'
okay.
paperwork, we did not have the copy of the child support order. We did have the worksheets, but no order.
Okay.
And I wasn't served with any of that, any of the child support information.
No, she's saying that they don't have that either. What he filed was a motion for temporary order, a proposed parenting plan, and a declaration in support of that parenting plan. And then Ms. Mills, just so I know how much time we might need, on December 26th, you filed a 20-page response. Are you intending to file your own proposed temporary parenting plan, or are you simply going to be asking the court to stick with the current temporary order in place?
I just want to stick with the current in place.
Okay. And that the current one in place, Ms. Looney, is the one that the current child support order is based on. Is that right?
Yes, Your Honor.
Okay.
So then do I need to file anything if I'm not asking to change it with
No.
you, Ms. Looney?
My understanding is no, but Ms. Looney can clarify. If she's simply going to be objecting, you don't need anything else from her, correct?
If she's not filing any additional paperwork, we would not need that, Your Honor. I just saw that it was noted there was a temporary child support order that had been presented to the court for today that we did not receive.
Okay. So, Mr. Mills, if you are proposing a new temporary parenting plan and a new child support order, make sure to serve those on the state of Washington through the prosecutor's office, so they have a chance to review it before we make a decision.
Okay, so serve state of Washington.
Yes, through the prosecutor's office here in Cowlitz County. Okay. So given that, let me get my calendar out. It does sound like we want to get this heard pretty quickly since we are very close to the 21 days, but not quite there. I could hear this, depending if the parties thought they'd be ready. I could hear this next Wednesday, January 4th. Or we could set it to January 11th.
It would be the 3rd or 10th.
I'm sorry. Yep, you're right. I'm looking at 2023. I'm going to keep doing that for probably another month. Okay. So the 3rd, January 3rd or January 10th?
The sooner the better.
Ms. Looney, how much time would the state be asking for?
We would just need time to review the order, Your Honor. If we needed to present something different, that might change our time frame. But if the court is wanting to decide the issue of parenting plan more timely, we can always request another hearing date for the child support matter.
Okay. So, Mr. Mills, I am, just so that the state can be as prepared as possible for whatever the court might rule, please serve that today or tomorrow on Ms. Looney's office, and we'll just set this over 1 week to January 3rd at 9 a.m.
Okay.
Ms. Mills, will that work for you?
Yeah, I just wanted time for you to be able to look over everything before any decisions were made.
Understood. Okay, we'll get you set on for review of Mr. Mills' proposed temporary orders on January 3rd at 9 a.m. And Ms. Day, I forgot to ask, I apologize. Are you available next Wednesday?
Yes, that's fine, Your Honor. I appreciate that. Thank you. I'll be there.
All right. Okay. Thank you all. You're free to log off on that. Steinwig, excuse me.
I'm here.
Okay. Do we have Mr. Olson today?
I have a cold, so bear with me.
Oh, it is going around. That is for sure.
I don't see that he's here.
Yeah, I don't see him either. Okay, let me get caught up here. We set this on today for review hearing when we were all last together. You all do right now have a non-jury trial set for January 29th, 2024, pretrial management January 10th. January 23rd is your readiness hearing.
Mhm.
Then I have the last thing I have is the certificate of mediation saying the parties came to a verbal agreement regarding a temporary parenting plan and have agreed to return for a third mediation session on December 22nd at 11 a.m. And was there any update from that, Ms. Steinweg?
So what happened was when we came to the agreement, the next day we came to court. And then he said that he didn't come to the agreement. So then you decided on our current temporary orders. And then we agreed that we wouldn't go back because it was basically a waste of time because we said that for 2 hours he agrees and then changes his mind.
Okay. And I recall him saying that, and I just wanted to make sure that you guys had not had a mediation session where you agreed to something after. I remember when he came here and said that you guys didn't agree, even though the mediator said you did. So it sounds like what we need to do is just keep you scheduled for your pretrial readiness and non-jury trial. If he fails to show for any of those, then you can ask the court for any relief you're requesting.
Okay.
Do you have those dates still for pretrial and readiness and non-jury trial?
Yes. And then am I able to get a copy of the hair follicle results? They were supposed to be sent to me by him or the company. Am I able to come in there to pick them up?
Let me double check since I don't handle that side of things. Let me ask the clerk where something is filed under seal.
Either one, just the parties.
Just the parties can. Okay.
With
So
ID.
with ID. Okay. So since it is considered a healthcare record and it's sealed, technically it means it's not a public record that anyone could access. But Ms. Steinberg, since you are a party, if you come to the courthouse with ID, you're going to want to ask for a copy of the hair follicle test results that were filed November 13, 2023. And then you can get a copy of that is what I'm being told.
Okay.
Okay. So I think what I'm going to do, because you have those future dates already set for trial, it doesn't sound like we need further review on this docket. So we'll just keep those January dates and see if he appears.
Is it documented every time that he doesn't appear?
Yeah, in our clerk's
Okay.
notes. So when you go in front of your next thing will be, I just had it up. Let me get back to
January
it.
10th, I believe.
Your pretrial management. And I believe that's with Judge Fassett. When you go in front of the judge, yes, Judge Fassett at Judge Evans at 9 a.m. When you go in front of Judge Evans, he will see in the clerk's minutes from today's notes, it'll say parties present and parties absent. And he
Okay.
will see that Mr. Olson was not here.
Okay.
Okay.
All right. Thank you so much.
All right. Thank you.
Morning.
I see both parties present. Are you folks able to unmute and turn your cameras on?
Yes, Your Honor. I'm here.
Unfortunately, I'm at work. I can't turn my camera on right now.
Okay, no problem.
I wasn't able to get 2 Wednesdays in a row off. I'm sorry.
Yeah. Okay, so I have this on for what I believe to be the final GAL review. I think we set it over. I think we set it over last time because Mr. Becerra wanted time to review the report. Mr. Becerra, have you received that now and had a chance to look at it?
Yeah.
Okay. Are you in agreement with it or are you objecting to the recommendations?
Objecting.
Okay. And Ms. Becerra? Oh, Ms. Becerra, did we lose you? Are you still?
Sorry. No, I'm still here.
Okay.
Recommendations.
Sorry, you cut out. I didn't hear what you said.
I said I'm agreeing with the GAL's recommendations.
Okay. So, Mr. Becerra, what are your points of disagreement?
Well, they're bringing up my charges, which were dropped, and I don't think that's relevant. It's not evidence. It's not facts. If they want me to do another parenting class, I can do it. I did a parenting class, a DV class, mental health evaluation. I still go to counseling at Core Health. I have 2 counselors. So I don't know, but I think I don't agree with it. It's really irritating to keep having to defend myself. And all I want to do is be a good dad to my boy. I'm not saying that, anybody's invalid for concerns, because I get it. They're kids and it's, you have to be careful, but I've done nothing to my child. I would die for that kid. And I just, I think that Ashley I don't want to accuse of playing a game, but I have evidence that she got back with me a year after the allegations. I have text messages, proof, everything. I think she's mad that I was not wanting to be with her at this point and is retaliating, because she even put in text messages she wanted to work this out outside of Keith. And so I don't know. I'm just a little, I try to remain calm with all this, but this is, I've even taken her out to dinner. I have a text message about thanks for dinner. I was trying to be very, very friendly and calm with everything that's happened to me in this. So I'm trying not to blast her, because I could have done all that and I could have thrown out all this stuff that I have, but I don't think that's the right way. I want to be a good parent and co-parent with my ex so that my child sees that his parents can get along. So why I was opting 50-50, or if I just get the every other weekend, I'll take it. That kid's more important than anything to me. I've taken and messed with my schedule so much for him. I've told them I can't work in this time because I have him, and I have a good paying job that I don't want to lose, but if I had to lose it for him, I would. So.
Well, so we're in an interesting scenario in this case, in that I see that back in June, and I obviously understand there's been a lot at play with both parties and child. But back when you all were in front of other judicial officers, you were on for, Ms. Becerra had requested a change in the parenting plan and an adequate cause finding. And what this court did was appoint Mr. Lawrence, I guess, to investigate this case further so that the court could make a better determination on that. I think the judicial officers we talked about last time put into place some changes in visitation. What I don't see, and Mr. Lawrence can tell me if I'm wrong, what I don't see is an actual order or decision on the motion for adequate cause.
I believe that's correct, Your Honor. In my investigation, I found 3 different parenting plans that the parties were referring to, and had very difficult time finding anything that the court had actually issued.
And I'm just going back now into 2021.
The last judge, he said he was going to sign an order for the new parenting plan that we were supposed to go by, but he never actually did it. So what we've been going off of was the court minutes that we got printed out.
Well, and usually when you're pro se, meaning you're unrepresented, the party who is proposing the temporary order needs to prepare that and supply it to the court. Now I'm all the way back in 2020. Okay,
I
so
did supply one in June, but he decided differently than what I had proposed. So,
right. So here's what I'm looking at. Back on April 17 of 2020, you all did have a temporary family law order that was in place and signed by a judicial officer back in 2020. And then I see it, like Mr. Lawrence suggested, I see a lot of potential proposals, but nothing final signed. And then in 2022, the clerk issued a notice for dismissal for want of prosecution, which just means there hadn't been any activity on the case in over a year. And then at that point, still nothing happens. But in June of 2023, Ms. Becerra files this petition to change a parenting plan. But the problem is, I don't think we don't have any final parenting plan. We just have a temporary parenting plan from 2020.
Yeah, and I didn't know that it was still just a temporary one. I thought when they signed it back in 2020 that it was a final parenting plan.
Yeah,
I didn't realize it was only a temporary one.
Yeah, it says court order signed by a judge or commissioner. This is a temporary order. And in that order specifically,
in that order, I think he was only getting 8 and 3 hours on Saturdays, but he was completely unsupervised with that visitation.
Yeah, this one, I'm just going back. There was some language the commissioner wrote in there. I was just looking at. Yeah, this one that Commissioner Busby signed, the child was to remain in the temporary primary custody of the mother pending GAL investigation and review. The father shall not be prohibited from having contact with the child, have residential time and visits with Aiden once a week for a period of at least 3 hours. With the anticipation of increase in the near future, parties shall use a third party to coordinate visitation, and this will not be a violation of the protection order. And then I know you all had some unique situations kind of happen in between then. So what I want to do today is a couple things. I want to specifically note on the record that in my ruling, I'm going to strike the motion for adequate cause because we don't have to have that, because we don't have a final parenting plan. We only have temporary orders in place. So I don't need to make a finding of adequate cause to move forward. I think the final parenting plan is still very much on the table. I want to talk about a couple of the recommendations. I am adopting, and the parties need to make note of this because you will need to prepare a new temporary order for the court to review and sign. On page 15 of the GAL's report, as part of a temporary parenting plan, I am going to adopt findings 1, 2, and 3. I want to talk about number 4 and 5. I am going to adopt number 6 as it pertains to neither party is to speak derogatorily about the other in Aiden's presence. The court should be advised that these are temporary recommendations. The last paragraph, the last sentence regarding polygraph and psychosexual evaluation are what I want to talk about now. So Mr. Becerra, this is recommendations 4, 5, and the last part of 7 regarding a polygraph or psychosexual evaluation. Those are the ones I want to talk with you about. And the primary reason I wanted you to have read the report in its entirety before we made this decision. I've thought a lot about this case after reviewing the GAL report, and I have hesitation to order polygraph. As most people know, we don't accept polygraphs as evidence in court cases. But I do think that Mr. Lawrence's concerns are not misplaced. And I do think before the court makes a final parenting plan, we would like to know more. We would like to make sure that the child is safe. And so Mr. Becerra, I wanted to kind of pick your brain. You are free on your own to do polygraphs if you would like. I see that you've done one in the past for a different case. That is your choice. I don't feel comfortable making that court mandated by any means. But then the option I'm left with is a psychosexual evaluation, which we do use frequently. And that's where you meet with a provider, an expert really, and they would make a recommendation to the court, which I'm more inclined to do. But they can be expensive. And I guess, Mr. Becerra, I wanted to know from you whether that's something that you think you have the means to do. I don't want to set you up for failure, or if you have other recommendations on how to satisfy some of the GAL concerns and, court questions.
Well, I'm not comfortable with. I've already done a psychosexual with no polygraph, and that was submitted a while back. I don't have the means to do really anything. I can take classes if people want. I don't care. I'm tired of being put through the ringer and the stress. I'm going through counseling all the time. I've been there for a couple of years now, and they're not happy with everything that I've had to go through, and they've had to work with me, and I've not been okay a lot. And but I mean, I don't know. I don't know. I just started working, making enough money. I have a second job to pay for a car because I didn't want to, when child support starts being taken out, I didn't want to not be able to afford my car because I need that to go to work. So I do extra work. I mean, you could even look at all my visits from when we were in DCYF stuff. I was put into monitored, and they had none. Even Judge Scudder, he said in his last thing that I had perfect ones. They never had a complaint. They never thought that anything was, and I was left alone with my son. And given it was only 15 minutes at a time, but I actually was so comfortable. I said, you don't have to go downstairs. You don't have to leave us alone. I had nothing to hide. I wasn't worried. So he could shoot. Lawrence could go and be on my visit. I don't care if he wants to see, or I don't know how to, I've had people on my visits. I don't care. It doesn't bother me. I did this for 3 years, and I bonded with my son, which every single person said that was amazing because it's hard to bond with a child just through visits. And I was doing 6 days a week with him. I tried not to miss. I was in 2 car accidents, and I still went to him. I just told him, "Hey, buddy, you got to be careful with Daddy. Daddy's hurt." But I just wasn't. I even went with a concussion. The kid's everything, and I really don't know how to, satisfy anybody with anything because there were allegations. It got dropped, but I get it.
Well, and what the court has to, I mean, there was probable cause found. So I just want to be clear on that. So it did move forward through that point, and it was dismissed without prejudice, which means it could be refiled within a statute of limitations period. So, so I guess that's, I'm just being realistic that, and I'll be honest, I have concerns about the parenting that has happened with both of you. I mean, there's, as Mr. Lawrence has pointed out, Ms. Becerra has also, I think, put the child in some situations that the court isn't totally comfortable with either. So, I want to be very clear about that. And here, so Mr. Becerra, you're telling me that there are counseling records related to some of the concerns that we're discussing here today. If I were to make those part of your requirements, are you still undergoing counseling?
Yeah.
How often do you go?
So I see a peer counselor and a regular counselor, but they've all switched. So
Okay.
I have people right now, but I continue to go to it because of the stress I've been under and to work through a lot of issues.
Is it is it mental health, or is it related to the sexual allegations, or?
No, it's mental health. And it was also something I chose to do because the court was asking me to get a mental health evaluation, and I cleared. I was good, but I thought it would be good under my own to go for it, to have that outlet. The ones I have now are new to me, but they're good. They're giving me because I lost my mom through this stuff
Mhm.
about 2 years ago, and if I weren't for them, I probably wouldn't be okay. They've helped me through a lot of my stuff. But I don't know if it pleased anybody, I could do mental health for sexual health stuff. I don't care. It really doesn't bother me.
Yeah. And let me
Really,
understood.
but
Yeah.
Your Honor, can I bring up one concern with the psychosexual evaluation,
Yep. Go ahead, ma'am.
at least from my perspective?
Mhm.
He did one through CPS that was prior to the charges being brought against him for my daughter. And then the judge required him to do a second psychosexual evaluation after the charges and the court thing had all happened, so that they could get an accurate account, because the first psychosexual evaluation had no idea about the pending charges. He did part of it, and then they asked him to come back in to do the polygraph part of it, and he absolutely refused and never completed that second psychosexual evaluation through our CPS dependency. And he's never had a polygraph, as far as I know, about any of the allegations against any of the other 4 children, other than the one that he did regarding Aiden.
Yeah, and that's where I've talked about this with other folks on the bench, and I just, our take is ordering a polygraph when it's not something we would deem admissible evidence. It's just not something I'm comfortable with. But I'm balancing that with, I have to make a decision what I think is in the best interest of the children. And I agree with Mr. Lawrence. I don't think, Mr. Becerra, that I have enough information to say that I don't have concerns. And so that's why I'm kind of leaning on you to see what you are willing to do. I mean, I am inclined to order a psychosexual evaluation, not the polygraphs. But I am inclined to order that. And I'm just wanting to get your feedback on whether you think that's something you can realistically get done. And go ahead.
it's as you know, they're lengthy processes.
Yeah, they are.
And where she's wrong, the first one was about the allegations, so they did understand that. And the second one, the lady, I won't talk on it because it is
okay.
part of that. And I was advised not to.
Okay.
And out of all respect, I don't mean any disrespect. I just
understood. It wasn't ordered by this court, so I'm not going to hold you to whatever happened there. But it does sound like, here's what I am inclined to do is to, because I do agree. I think there's enough here for concern before we enter permanent parenting plans. But I also, Mr. Becerra, am trying to balance that with, I'm not here to hold every allegation that someone could make about you against you. And I think the way for the court to know whether to move forward is to get that psychosexual evaluation. But I'm not ordering the polygraph. I don't think that that's something that would be valid standalone. Obviously, if the psychosexual evaluator wants that for their own data points, that's up to them. But for the court's perspective, I'm not going to order standalone polygraphs. So what I'm going to do, besides adopting on a new temporary order, is 1, 2, and 3. I am going to strike 4 and 5. My new recommendation or my new order will be that Mr. Becerra complete a psychosexual evaluation with the input of Ms. Becerra and the GAL. And then under number 7, that last sentence then from the court's perspective would read, once the psychosexual evaluation is completed, the court will review further recommendations.
Okay, Your Honor, do you go through and order the child support? Because at this point, Washington State has dropped child support, and Joe has only paid me child support outside of an order once since I've had my son back in my custody.
Right.
Is that something we go through you, or do I do it through Oregon since I live in Oregon now?
And where do you reside?
I live in Astoria,
Okay.
Clatsop County. I moved down here to get out of the relationship that caused the CPS case.
Okay. Ms. Looney, do you know the answer to that? I don't want to put you on the spot here, but since let's see if she's with us. I don't want to.
I apologize, Your Honor. I am here, but I wasn't focused on this hearing since I'm not involved.
Understood. And if you aren't comfortable answering this, don't. This is a situation where we have a current parenting plan that's been in long works while these parties resided in Washington. Ms. Becerra is now in Astoria, and we're going to be entering a new temporary order. And she's wondering about whether she needs to go through Oregon for child support or file her documents with you.
I'm just checking to see if they're in our system, Your Honor.
Okay.
We might not be because they closed it out about 2 years or a year ago, 2 years ago, I think.
I see that when this case was, when the clerk entered the notice for dismissal for want of prosecution, then the Ms. Looney's office did file a notice of withdrawal. But it does say all further notices should be served directly on state of Washington at DSHS.
That's correct, Your Honor. And I'm just looking to see if they have an active DCS case open, and I don't see one currently. So at this point, I would not have an answer for that.
Perfect. Okay. Thank you. I appreciate that.
No problem.
So
Yeah, I'm not receiving any state assistance other than like food stamps and medical for our son. So unless I get TANF, they don't require child support orders be in place.
Yeah. So Ms. Becerra, I can't give you legal advice from the bench. So here's what I'm going to say. I do want you to fill out a new temporary parenting plan based on my ruling today, which is based on the GAL findings. And then we'll set a presentation date for that, for a judge to sign that order. And then you can serve that. If you want to get some legal advice on whether to serve that in Oregon or Washington, feel free to do that. But you can request child support based on that new temporary parenting plan being signed.
Okay. And Joe and I had tried to work out child support outside of having to do it through like the state and making the state take money out of his check and, send it to me and all of that. But like I said, he only did it 1 month and then hasn't, and told me through text message that he wasn't going to give me any more child support until this all dealt with.
Yeah. So that's child support isn't in front of me today. So again, I'm just going to say, what I can do is Ms. Becerra, how long do you think you'll need to get the new temporary order proposal filled out per my ruling today and then back in front of this court?
Well, considering I live an hour away and I work Monday through Friday, 8 to 5, I'm going to have to take a day off so that I can come up there and file everything.
We have this docket every Wednesday at 9 a.m. So do you want me to set it out 2 weeks to January 10th?
I will try to have it in before next Wednesday. I can see if I can come up and do it Friday.
Okay. Well, it wouldn't be in our system yet. So if you're planning to do it Friday, let's still stick with January 10th. So it has plenty of time for Mr. Becerra to receive a copy. Please send a copy to Mr. Lawrence. Mr. Lawrence, are you staying on this case for a bit? I'll probably need, if you are willing to do so, I'll need to authorize probably additional resources.
That's correct, Your Honor. I usually until there's a final parenting plan. Before the court ends the hearing, though, I would like to make a couple of comments.
Yes, I'll come back to you in just a minute. So Ms. Becerra, we'll set this for January 10th at 9 a.m. And again, please serve Mr. Becerra and Mr. Lawrence with a copy of what you're filing with the court, okay?
Okay, can I email it to Mr. Becerra or do I need to hand it to him?
Mr. Becerra, would you accept email service?
You can, yeah.
Okay, yes, you can email. Okay, Mr. Lawrence, go ahead.
Well, Your Honor, I understand where the court is right now and the ruling you've made. I just wanted to share a couple of things. I was working with sex offenders for the Cowlitz County Juvenile Department in 1990 when the Community Protection Act went into effect. And it required special certification for anyone evaluating a sex offender and treating sex offenders. And mental health centers were specifically forbidden from working with sex offenders in that statute because of the lack of understanding about the nature of the sex offender dynamic. The reason that the polygraph is part of the evaluation process is that if an alleged offender goes in for an evaluation without the polygraph, most of the time, and if not all of the time, they are going to minimize and deny any activity. And the evaluation becomes almost worthless at that point because there's nothing to work with if the person is denying that they have done anything. That's why the polygraph is so important, to understand exactly what we're dealing with. Now, I understand that the court has spoken to the other judges, and I understand that this is your ruling, but I want the court to be prepared that the evaluation, if completed, is probably going to have minimal value.
Thank you, Mr. Lawrence. I do appreciate that input. I did review in depth your credentials regarding this specific topic that were in the report. I appreciate that. Yes, I disagree. I don't think that a psychosexual evaluation, as I have ordered it, is going to be of minimal value. What I've stated specifically on the record is that if the evaluator believes a polygraph for purposes of their data points is appropriate, they can certainly discuss that with Mr. Becerra. What I don't believe that this court should be doing, which is supported by other judicial officers, is ordering standalone polygraph examinations. We don't, if that was presented as evidence to us, we would deem it unreliable. So that's what I guess my ruling is very specifically that I'm not ordering the polygraph first and then determining whether to do the psychosexual evaluation. In essence, I am leaving it up to experts in this field to decide what they need for their data points.
All right.
But Mr. Lawrence, I do appreciate your wealth of experience and knowledge in this field. And I do understand why you are making the recommendations that you are.
Thank you.
Okay, so I'll see the parties back January 10th, 2024. Oh, Mr. Becerra, did you have a question?
Yeah. So am I getting 3 hours professionally supervised? Because that's confusing.
This is, so I guess that is a clarification we need to make in Mr. Lawrence's report, and thank you for bringing that up. Right now, I believe it's your sister who's doing this supervision. Is that correct? Is that yes?
Yeah.
Sorry.
Yeah, sorry.
Okay. And I think Mr. Lawrence's question was, we should talk about whether the sister is the best supervisor for this situation. I understand what the potential concerns might be. Ms. Becerra, are you comfortable with Ms. Medina, or are you requesting a change?
Joe already knows I'm.
Sorry, you're cutting out. I couldn't hear what you said.
Oh, hold on. I think my headset's
Okay.
going dead.
Okay.
So I am going to request a change on the supervision person. Joe will obviously deny this fact, but he has told me in person that during our CPS investigation, Miss Medina would allow him around our son outside of the approved hours and times that he was supposed to see him. I don't feel that she is necessarily the most like by the book, rule abiding person to be supervising the visitation with my son. Just because of the prior things that have happened. There was reports made to our CPS person at the time when I found out that he might be having extra time with our son. And then shortly after that, our son was removed from Michelle's care, put into Brielle Balzer's care. And then he was having supervised visitation through an actual supervision company after that, because of concerns of her not abiding by the rules. I don't like the other two people that he has supervised are the best option either. Cindy, whatever her last name is now, it used to be Balzer. I think it's Wolf now, and Michael Wolf. They are the mother and mother's husband of the kids' previous foster parent. And that foster parent tried to keep me from getting my children back by lying about me in reports. And so I don't feel like they are necessarily not like, I don't think they're not going to pick sides and just, allow him to do whatever he wants to do, just because they never wanted my son to come home to me to begin with. So,
Mr. Lawrence, what are your concerns with Ms. Medina, if any?
My only concern, Your Honor, was whether or not the relationship between her and Joseph would be a potential situation where she may hide some information. That's why I brought it up, just for discussion. I wasn't suggesting that she necessarily be removed.
Understood.
What I understand from Ashley's comments are that she hadn't been objecting to Ms. Medina supervising Aiden currently, but had an issue that occurred back when the kids were in foster care and removed from the home. That doesn't seem to be relevant today to me. And unless there's a party that both of these folks can agree on, particularly unless, and again, I'm qualifying my statement here, that should the psychosexual evaluation prove that there is some issue, then I would want to immediately revisit this issue. But for now, I can live with Ms. Medina.
Yeah. And that's kind of the way I'm leaning as well. And, Ms. Becerra, I want to be perfectly blunt here. This is a situation where I have concerns about your parenting choices as well. So I need to be very, very clear with that. I think there's a lot of casting of doubt on Mr. Becerra's parenting, and I'm not saying it's without some factual basis, but I don't have anything hard pressed in front of me to say that Ms. Medina right now is an inappropriate supervisor for where we are at. I agree wholeheartedly with Mr. Lawrence, though, that should, as we continue down this path, additional information come out that Ms. Medina is not an appropriate supervisor, this court absolutely will revisit that when faced with that type of specific factual allegation. I am going to leave Ms. Medina right now as the appropriate supervisor for the reasons I've stated, but also I am placing on Mr. Becerra a large financial expenditure and adding professionally supervised visitation. I think financially is just out of the question given what I have in front of me. Again, like Mr. Lawrence, I'm going to preface all of this with, should the evaluation tell me something differently, I certainly will revisit this and we can talk about whether professionally supervised visitation is warranted. But right now, I don't believe that I have enough in front of me to say that it is. So I will, rather than professionally supervised visitation on this temporary basis, it will be with the previously agreed upon family member, Ms. Medina.
Okay, so does that mean I drive Aiden up and drop him with Michelle for those 3 hours for Joe to see him and then pick him back up? Do we have to meet somewhere? Is that just going to be on Joe and I to decide how and where those 3 hours occur?
Didn't we already discuss that when you were in front of Judge Scudder?
No. I mean, I take him up and I drop him at the courthouse with them, but I didn't know if, is there going to be a specific place that you like want that visitation to happen? Am I, is it supposed to be public? Are they okay to go to his sister's house for those 3 hours? I just want clarification so that when, things are said, then I don't, go against what your recommendation is for that.
Okay, what are you wanting clarification on?
So he is just getting the 3 hours of supervision, right? Supervised visits a week?
Correct.
Okay. So
On
then
this
is
temporary basis, before he
Okay.
undergoes additional evaluations, yes.
Okay. So is it just between me and Joe to decide what day and times work for him as far as those 3 hours? Or are you going to set aside a certain day?
So I'm going back to the notes. Previously, I believe, if these notes are correct from when you were in front of Judge Scudder, that each party would pick up at the beginning of their own time. And that I think the court set Saturday at 10 a.m.
That was one of them that he said. And then he went back to Friday nights at 7 p.m. to Sunday nights at 7 p.m.
Okay. And transfer to occur at Hall of Justice.
Yeah.
And then you were encouraged to work together if those times don't work.
Yes.
Okay. So during the 3 hours, I'm not putting any limitations on where that visitation is occurring, except that it has to be with Ms. Medina present. I believe that the transfer of the child are you still doing it at the Hall of Justice?
Yeah.
We either do it there or at the mall, because I also pick up my other daughter at the same time, generally, if we're doing Friday night exchanges. And so it just kind of has depended on like where I can meet both parties at the same time.
Okay, so it sounds like that's something you guys are already working together. So why don't we say Hall of Justice or Three Rivers Mall? Parties to work on that together. Those will be the two places. It sounds like, Ms. Becerra, you will be the one bringing him here for the 3 hour period. So what works for you?
I work Monday through Friday, 8 to 5. So if it can be a Saturday or Sunday, that's okay with me.
Mr. Becerra, what works for you and Ms. Medina?
I don't know on time,
Okay.
but Saturday can work, and I can figure out the time with Ashley.
So let's say a 3 hour period on Saturdays, time to be coordinated between the parties. And if you guys could coordinate that, let's say by Wednesday of, 3 days before. So Wednesday of the week, have coordinated your times for Saturday.
Okay.
And then again, no other limitations I'm placing on visitation except that it'll remain supervised. January 10th is when I have you all coming back for presentation of that order. And then let's set a review. I know Mr. Becerra getting in for an evaluation is going to take some time, but I would like to get a review on this docket so that once you have started that process, the court can continue to modify visitation as appropriate. If we set a review for February 7th, that's about a month out from presentation of the order. Will that work for the parties?
Yeah.
Okay. We'll do the first review February 7th at 9 a.m. primarily to see where we're at with the evaluation.
Okay.
Okay. Any other questions for me?
On the parenting class thing,
Mm-hmm.
do I have to come up to Washington to do that parenting class, or can I take one here in Astoria?
That I have.
Is it just one of those 11 parenting class?
Wherever they offer it.
Your Honor, if I can interject.
Please do.
Some of these are online. Love and Logic, and I believe Children in Between may both be offered online.
Okay.
Yeah, I'm not placing any limitations on where it has to take place, just that it needs to take place. So online, in person, whatever state works, just get it done. That's all I care about.
Yeah, I know. I was just clarifying because of the CPS case, I had to drive all the way to Longview. Like, 3 times a week for the classes.
Yeah, I wonder if, and were those done through CPS itself or just recommended by them?
Yeah, it was done. They were recommended and they were done through Stacy. I cannot remember her last name. She's there in Longview. She does both the DV classes and the parenting classes.
Yeah, no, this is much more, I believe Mr. Lawrence is very accurate that a lot of this you can do online.
Okay.
Especially post Zoom world. So, okay, well, we'll see the parties back on the 10th. Ms. Becerra, if you fill out that order, if there's clarifying questions that need to be made on the 10th, we can deal with that at that time. But go ahead and fill it out to the best of your ability to present for the court.
Okay, and that's just the temporary order, right?
Correct.
Okay.
Okay. All right. Thank you all. I appreciate your time.
Thank you.
Sconiers, thank you. And Mercedes Thomas. I do see Ms. Looney there, and I do have orders.
Good morning, Your Honor. I was just looking at our orders and noticed that we do have a slight clerical error regarding the division of support for each child, which we can correct as we get there.
Okay, perfect. Go ahead.
So this is the stage motion, Your Honor. There had been previously some mediation between the parents. The last information we had was that that had not been successful, but due to the fact that both parents had filed parenting plans requesting that the mother remain the custodial parent, we did file a motion for a temporary child support order because the current administrative order only covers one of the children. So we're asking to enter the order today so that both children will be covered under the same order.
Okay. And I did see that, and I did see that those were served to the parties or remailed.
Yes, sir. So we did mail to both parties on November 28th.
Okay.
We did receive paperwork as returned mail sent to Ms. Thomas. We did get that back on the 19th of this month, and the same date did send that back out to her via mail as well as email.
Okay.
So we believe that service is proper for her as well as for Mr. Sconiers so that we can move forward today.
Okay. Okay, go ahead and let me know where the clerical error is.
I will, Your Honor. So we would just be requesting that the order be entered with the $753 transfer payment for Mr. Sconiers to Ms. Thomas in section 10 on page 3. We just have transposed numbers. It should be $376.50 each for the children instead of $367, but the total amount at $753 is accurate.
Okay. Good catch on that. I don't know if my non-math eyes would have caught that. Okay, I've made that change and initialed.
Thank you, Your Honor.